Hello and welcome to this CEDR Court of Appeal guidance on how to represent clients in mediation. In this video, I'm going to talk you through how the mediation process works and the particular techniques and points that you need to do as the lawyer representing a party during a mediation. My name is Frederick Way, and as well as being a CEDR panel mediator and trainer, I also work as a negotiation consultant and manager of the CEDR Foundation, a not-for-profit organisation. I regularly mediate, including with litigants in person, and also teach lawyers how to be better as lawyers in a mediation. So, before we go further and I talk you through what you should do at each individual stage, I think it'd be useful to talk about what is mediation in general, as this is something that it would be helpful for you to be able to explain to your client and also for me to just emphasise the key features that are relevant. So what is mediation? Well, here is a CEDR definition. Mediation is a flexible process conducted confidentially in which a neutral person actively assists parties in working towards a negotiated agreement of a dispute or difference with the parties in ultimate control of the decision to settle and the terms of resolution. There are some points there that I just want to emphasise because they'll be useful for helping your parties, especially with litigants in person, to understand the difference between mediation and other processes, for example, court-based processes. The key thing that you can see there is that mediation is a negotiated agreement and the parties are in control. Therefore, as a lawyer, your role is not just to represent the parties, but to actually get the parties to be actively engaged in the process. The parties need to be making the decisions, and the parties will be the only people who can resolve and settle the dispute. Therefore, what a mediator is doing is helping the parties to be able to achieve that. But a mediator does not provide the parties with the solution for what the settlement should be, rather it's the parties who do it themselves. This means that the parties are going to have to be more actively engaged than they might be in other types of processes. Similarly, if we look at the start, there's an important point about the fact that mediation is flexible and therefore can happen in many ways, but also that it's conducted confidentially. And I think the confidential thing is something which is incredibly important to emphasize to parties, in that what they tell a mediator is confidential and the mediator will not report it necessarily to the other party or to any other court process. This means that they have an ability within the mediation process to be creative and to consider solutions which they may not feel comfortable to consider elsewhere. So, what should be your overall aim as the lawyer representing a party in a mediation? Well, I think this is simple. I think your primary aim at a mediation should be to help your client to settle if that is appropriate to do so. So your role is not to try and win the case. It's not to try and prevent the party from settling. It's to help the party, if there is an ability to settle, to do so. And when we think about what a settlement is going to be, and that will be obviously coming out in full and final agreement in full and final settlement of the dispute, then your role is to help the party, to your client, to get to a settlement which is appropriate. And so that agreement must have really two things. Firstly, it needs to fully meet the needs of both sides, not just their legal rights. And when I say both sides, it's actually something where it's important that you're not trying to just win in a mediation. You're actually trying to come up with something which is going to work and is going to allow the parties to really resolve what's driving the dispute, not just maybe what's on the surface. And secondly, and this is critical, in that your role is as a lawyer is to ensure that they're protected from further legal challenges. So you need to make sure that the agreement is binding, watertight, and that it concerns all of the things that might be relevant to the parties. So to summarise there, I think your role as a lawyer really is to help your party and your client as much as possible to be prepared to mediate and to realise that they're going to have to take an active role and be able to do so appropriately, but also to protect them. And so it may be that you're saying that they shouldn't settle, but that is only if a legal right is invoked, which would require them to not settle. And instead, you should actually be trying to think about ways that you can encourage them and help them to settle within the process. Now I'd like to talk to you about the mediation process itself. When you go into a mediation with parties, you'll find that most mediators will follow a standard process of the mediation. This is to encourage parties to settle and also to prevent the problems that normally have happened in the past which have prevented them from being able to reach an agreement. The process model I'm going to show you is one that almost all mediators will follow. And although the process is flexible, this should be the one that you're expecting and has particular elements that you will need to do during the process. So the process model can really be seen to be split into 5 different bubbles, and this is to allow the parties to move from a starting position all the way through to hopefully reaching a settlement at the end of the session. So obviously you need to start with preparation, and we'll go through what that is, but you need to help your party to be prepared for a mediation, to be prepared to negotiate, to be prepared for thinking about what the other side might want, and all of the elements that need to go into working in a way which is different from being in court or another type of legal negotiation. From preparation, we move to the first moment which actually takes place on the day, which is the opening. And so, including in doing cases with litigants in person, it's incredibly important to do an opening. This is when the mediator will bring both parties together into one room and ask them to make an opening statement to the other party about their feelings about the case and their position, and then also to hear from the other side. This has many benefits, but one of the most important with litigants in person is it actually allows them to have their day in court, so to say, to express how they feel about a case. It also allows the lawyers and parties to set out quite clearly what a further bargaining position might be later on. So this is an important session, and this normally takes about anywhere from 30 minutes to an hour in some cases, and is one that's controlled by the mediator. After that, the parties will then normally go into their separate rooms, and the mediator will use shuttle diplomacy to move between them. Now, what happens here is the next stage is incredibly important. And the reason that most negotiations or most mediations would fail is that parties will, at this point, having done an opening, go straight into making offers. And that's normally where things go wrong, because parties are actually not in a position to make offers. Instead, what mediation does is to slow down and go to a position of exploration, or which can be summarized as information exchange. This is really where the mediator is driving down what actually matters to a party and what their needs are. So, for example, if a party was asking for £100,000 in a case, the exploration is allowing the party to actually explore what is the need for that £100,000, and so that the bargaining positions can be opened up later on in order to find maybe alternative solutions, or to find ways to structure the offer in a way that the other side will be more receptive to it and persuaded by it. It's an incredibly important stage, and it normally takes a considerable period of time. Maybe 40% of the mediation time will be spent on exploration with the mediator working with the parties on that position. Once exploration has taken place and a broad understanding of what a settlement might be has been reached, the parties will then actually be in a position to move into the next phase, which is bargaining or deal making, where they can make offers to each other, and there are normally a series of offers that are made. At this point, it's incredibly important that the lawyer is helping the party to make appropriate offers and to structure them in a way which will allow for full and final settlement. Finally, the parties will move into a phase of concluding or settlement, and this is where the lawyer will help the parties to have drafted a settlement agreement which will be binding in full and final settlement on the parties. So that is how you move in a quite linear way from preparation all the way through to concluding a settlement. But as I mentioned earlier, what's important is the process. It's flexible and the mediator will be in control of it. So, for example, if during an offer it seems that there's another issue that has arisen which is preventing these offers from being accepted, the mediator can take the parties back into an exploration mode to actually identify more what's going on before the offers are made again. So this will prevent deadlock. Similarly, if you get to a final point in concluding and there's an issue that might have arisen which just needs a final bit of understanding, for example, tax is quite a common issue that arises right at the last minute, the mediator is able to take the parties back into bargaining to discuss that issue before proceeding into concluding. Also, actually, if there's a major issue which arises, the mediator can take the parties back into exploration, then move them through from exploration on that issue through to bargaining again and on to concluding. This model is one which the parties need to be prepared for in the day, that it's going to take this extra bit of time, but the point of this is that it actually allows for settlement to be reached and for parties to understand what they are doing. For the rest of this presentation, what I'm going to do is to talk to you about the top tips that you as the lawyer representing a party, and in particular a litigant in person, can do at each stage of the process. So first, tips for preparation. And I'm aware here that you may be possibly able to meet your party in advance and able to do effective preparation, which is the ideal situation, and I'll talk through tips about that. But I'll also talk about if you are having to do last-minute preparation because you haven't been able to meet your party in advance, still the things that you need to be preparing your party for. So, tips for preparation. I think the first most crucial tip that you can have is to talk about the mediation process with the mediator and your client. And this obviously would ideally be several days in advance if you've got the opportunity to talk to a litigant in person. But even then is before the mediation process starts. If you're talking to your client, you need to make sure that your client is aware of their role in the mediation, that they're aware of what the mediator is doing, that the mediator is neutral, that they understand points such as the mediation is confidential and that the mediation is without prejudice, which can obviously be explained to a client as saying that nothing that occurs in the mediation can be referred to in court. The second thing which ties in with that is managing the client's expectations for a non-court-based solution. Clients often have a feeling that court is the only solution that is appropriate and that they need a judgment in order to be validated. In fact, here they are going to have a non-court-based solution, and therefore the deal that they come to could be far more personal and could have elements to it which a court could never order. For example, publicity clause or other elements such as that. So the client really needs to be prepared for the fact that they are not going into court. There are also things that the client will need to think about in advance that go beyond just their legal rights. And this might be something that if the litigant person has gone quite a long way down the road of the law, has not thought about and has not realised that things are going to need to be solved. So some classic things that they will need to think about is obviously they need to know the commercial details that will allow them to make a decision to resolve a case and to find a settlement. But they'll also need to think about things like PR. So, for example, some litigants might have wanted to make some sort of statement after their mediation, and they'll need to think about what they'd want with that, but also timing and logistical issues, everything that goes into making a settlement workable. And they need to have thought about this in advance, or if you're meeting them on the day, they need to think about it before you start doing the mediation, because it will help the mediation be successful if they thought about it. Something here to also just emphasize is that it's useful to think about the other party's commercial issues and other issues as well. And if you know them, you can actually plot those in advance. Now, this is something that mediation should ideally always have, and that's agreeing supporting documents and a case summary with the other side. This goes to the mediator, but it also goes to the other side, and it's a short document, 4 or 5 pages, outlining what the position is of the party and also roughly what has happened in the dispute to date. and any intentions for settlement. Just some important things that you can include in that. You can include a chronology of the dispute and offer's date. Is also really useful to include, and actually may be vital to include, the legal cost dates and the estimated costs to trial, so that the parties have this information so that full settlement can be made during the dispute, during the mediation. Other things that you need. A draft settlement agreement is something that is incredibly helpful to have. There is a standard settlement agreement on the CEDR website at www.cedr.com in our model documents section. And this is something for you to look at, and in order to edit and arrive with. Although you won't sign the agreement till later, it will save time if you've already thought about what the terms of such an agreement might be. Something to think about is also, based on the particular case, are there other things that you will need to settle? It may sound stupid, but I have dealt with cases such as ones involving transfer of leases, where parties have not realised they would need to bring the lease transfer document with them. Therefore, if there are other elements that will need to be signed, e.g. additional contracts, you need to think about those and bring them with you. Preparation. Who will attend? Obviously you will attend and your client will hopefully attend, but you need to think about the other parties, the other people that your client might want to bring with them. Thinking of litigants in person particularly, it's important to think about whether or not they need to bring any business partner with them. If they're representing a company, do they have somebody who can actually answer the financial questions? Additionally, do they need to bring a partner or spouse with them? Commonly, litigants in person will want to talk it through with a friend, and it's quite common for that person to attend. A slight word of warning here, you really should try and discourage people from bringing everyone to a mediation, because it won't help. In fact, what you need is the key players and people who are going to help the litigant in person make a decision in the mediation which will allow them to settle. Finally, within your preparation, you do need to think about negotiation strategy, and you need to go through this with your client. What are you thinking your offers might be? What are their offers likely to be, and how will you respond? How will you persuade them towards what you would like to happen? These are all things that you will need to think about in advance and to have a clear understanding so that you can help the litigant in person make a good offers during their mediation and hopefully get to settlement. Now let's look at the opening phase. As mentioned before, the opening phase is a time when both parties will make statements to each other, expressing what their case is, giving a chance for the actual lay clients to express their view, and opening up a position for the rest of the mediation to exploration and bargaining. This is actually an incredibly critical phase of the mediation. And the reason it's critical is because it sets the tone for the rest of the mediation. If you do it well, and I've seen it done brilliantly, you can make the mediation go much better by the fact that you're encouraging the other party to work with you. On the contrast to that, if you do the opening badly by maybe being overly aggressive, then you can actually set the tone negatively for the mediation and encourage the other party to make you tough offers or to not even engage with you at all. So it's an incredibly important time. So looking at the tips for the opening. So the first thing to say is normally in an opening what will happen is that the mediator will, after making their own introductory remarks, setting out what happens in a mediation, will invite the claimant side to go first, and they'll ask the lawyer normally to speak first and make a statement, and then invite the lay client of the claimant to make any additional comments they want to make. And then they will ask the other side, the defence, to in a similar manner. So for the defence lawyer to make a statement, and then for the defence client. Some points here about what you're doing. The first is that you're persuading the other side. You're not trying to persuade the mediator. So really think about the fact that you're going to be talking to a person in a room, that you're not trying to win an argument in front of a judge, or nor are you trying to make the mediator emphasize with you. What you're trying to do is to persuade the other side. So think about that and language. Length. Normally, an opening statement needs to be no more than 5 minutes. You don't need to go into all of the details about the case. Instead, you should do a summary, and really the focus of it should be on what you want to achieve today. And hopefully that should be a positive statement. It may be something simple as, we are here to listen. We have a strong case. We understand, we recognise that, we don't want to go into it, but today we're here to listen to what you want to do and see if a settlement is possible. And that really, that what I've just given you there as an example is a way of influencing negotiations by setting the right tone. So I've already said it's incredibly important that you try and be as positive as possible without giving the, you don't have to give everything over. We're not asking you to roll over or anything in this section, but we're asking you to be reasonable and to help your client by being as positive as possible. Think about who is best to present. So this is really thinking about if they're litigant in person or if there are multiple clients present. There may be people who are more or less antagonistic or who you just know will phrase things better than others. It really is quite an important thing. So do think about who might present from the client's side. This is actually a really important one. Listen carefully. You might learn something new. Often people, especially people who've been to mediations a lot, start to think of the opening presentation as just being something to get out of the way. It's not. Actually, you'll often hear from the other side what's really critical to them, and they might say something, for example, I just want to get on with my business, which will allow you to open up what offers are later on. So it's really important that you listen carefully to the other side when they're speaking during the opening. If you are going second, or even if you're going first and you already know what they're like to say, it's important to acknowledge their views, even if by stating disagreement. This really helps for them to feel that they've been heard. There's nothing worse than if they say something and they're quite upset, for example, the claimant, and then the defendant doesn't even acknowledge that the claimant has said something. So it's really important as the lawyer, and if you can encourage your party as well, to acknowledge that the other person has a view. You may completely disagree with that view, but you do understand it's there. And finally, I would say to acknowledge any imbalance of emotion. This can happen quite routinely, but where, especially with litigants in person, where people can feel, one party can feel a lot more emotional than the other. If there is that imbalance of emotion in the room, it can be it doesn't require you to in any way give up your position, but to acknowledge that that exists and that the other side maybe feels very upset about something, and that you recognise that you want to deal with it, but that it is different from how your party feels. So, moving now on to the expiration phase. This is the phase where, as a lawyer in the mediation, what you're really doing is you're letting your clients speak. And during this time, your client is going to be exploring with the mediator what's driven them, what's driving them, and what they might consider as driving the other side, to be able to get a broad basis for settlement later on. So, for example, in a partnership dispute, for example, what might happen during the expiration phase is that you might explore whether or not the partnership is going to come to is going to cease, or whether there's going to be it's going to continue. And the way you do that is by finding out as a mediator about why people entered the partnership, what they sort of hope and dream for, everything like that, and what actually do they financially need right now. So as the lawyer, you can really let the party explore. It's quite an important point for them, but you're also just protecting your party and helping them if there are legal issues that arise. So, some tips for expiration. Firstly, this can take place, just to mention, in private and joint meetings. It normally happens in private, so the mediator will be speaking to the party confidentially. Something you can just do is just to reassure your party that when the mediator is speaking to them in private, everything that's said will not be repeated to the party in the other room. And that's an incredibly important aspect of mediation. It's one that can be mentioned. You may also have some joint meetings. These might be about general fact-finding, or points that need to be decided between both parties, for example, about financials, might come up very early. What you're trying to do in this phase is to help use the mediator to move beyond the positions and rights that the party and the other side are demanding, to really look at interests and needs. So, for example, the other side might be saying they have to have 100,000, but what you're trying to do is to help find out what is it that they need, what can be done to achieve that. You're using the mediator here then to widen the possibilities for settlement. That is exactly what you're doing. Everything here is about expanding out to allow you to make a better deal later on. And as I said, learn what matters to the other side. Something that you can do, which is quite sophisticated here, is to really recognize value differentials. This doesn't mean that you're caving in any way, but you may quite easily recognize here that there is something that is important for the other side, which you disagree about its value, but you can recognize and hold that this is of importance to them. Really, to summarize then, what you're trying to do here is to identify and agree a very broad route to settlement. And you can let the mediator to help the parties move through in order to get there. It will be a natural process. I think that your main role is to encourage the party to open up here and to continue doing that, remembering that nothing is final until it's signed, so that you have that opportunity. Okay, so we've now explored and we've identified a broad route for settlement. We're now moving into that fourth phase, which is bargaining. This is really when you're getting into the difficult, or not the difficult, but the meat of the mediation in many ways of making offers to each other and reaching a settlement. So tips for bargaining. What you're trying to do here is when you're moving into this phase, and the mediator will know and help you work through into when that phase starts, but you're building on your understanding that you've gathered in the exploration phase of what the other side needs. So you're really understanding that, for example, if they have a need for a fast payment, that is going to be part of your offer. It may not be something that's quite as clear that to you, but you may understand that, for example, that actually speed is something that matters to them, and so it helps you with the offers that you're going to make. A useful thing to know here is that actually making the first offer can actually be often a powerful move and something which will anchor the negotiation zone. So, for example, if I want £100,000 and I make a first offer of saying that actually I've thought about it and I'll move to 81,000, that can be quite a powerful message to the other side if it's considered to be credible by them, and will allow you to maybe reach that goal or reach close to that goal. So think about when you are bargaining and when you've got to this stage of the mediation, like I really want to hammer that point home, not too early, but about making that offer, because it can be a very useful thing to help things move along and to also help get towards what's important for your client. You should always articulate the rationale for an offer. So when you make it, so you shouldn't just swap numbers. So you should explain how you've reached there. You should also explain and think about persuading with your offer. Why is this something that the other side will satisfy the other side's needs? Why is it something that is going to work? So bad offers are just to say something like, I will now accept 81,000. I've reduced it from 100,000. That doesn't really tell the other side anything. What you actually want to do is say why you've come down to 81,000, why that money is necessary, but also think about the language for the other side as to what will make them agree with and accept that figure or persuade them. And so that's really, as I've just said, using the other side's language can be a really helpful thing to do there. So if they use words like a need for speed or something like that, then that's something to work into how you make your offers. You can use value differentials to actually begin to get agreements. You can say, look, we understand that this is a critical issue for both of us, but we have different ways of thinking about it. We have different values on that. And you can use that as a way to start to actually get to think about it and start a process of agreement. Remember that mediation is a flexible process, and it is one which isn't binding until it's finished. So actually you can try out new ideas. You can say hypotheticals. what would happen if this was the case? If there was all the money in the world, what could we do? And then from that, maybe work through. So you can actually be quite creative with the parties. Finally, with this, just really to remember to manage your tone, keep it calm and productive. You do not want the parties to, at this stage, when they start to get into numbers and it's moving into that phase, it can get more tetchy. And what you want to do is to make sure that the parties are still calm, that they still see this as a positive thing, and that they so remember to manage your tone. Okay, we've reached the final stage, and so I just want to give you some tips for concluding and settlement. And this is really about what you need to do a binding deal. So if we go at the top, so with this slide, so the top 3 points are about assuming you've got to settlement. The first is make sure that you've obviously included all the issues that need to be resolved. You can't leave anything. Do take time to finalise the draft and go through it with your client. It's incredibly important that they understand what it is that they're signing up to, and that it includes all of those issues that we mentioned. So, for example, have they actually thought how this will affect, for example, their spouse, or have they thought about tax? Have they thought about anything that might arise? And so that's something also about checking workability. You really don't want them to sign up for an agreement which they have no chance of being able to fulfill, because it will just fail and then you will have a problem. If no settlement is reached, and remembering that it might not happen, in most mediations 70% of cases will settle on the day, but maybe another 10 to 15% of them will settle shortly afterwards, so there'll be progress made and the parties will be able to settle in the following week. So think about ways that you can encourage that to keep going. Even if there is never going to be a settlement, there is still positives that can be taken. So if no settlement is finalised, you should ideally have a final meeting between the parties before they just go away, rather than just walking out. The mediator will encourage you to do this, but you should acknowledge progress that's been made, especially if it seems the parties have gone quite far. Agree the issues that need further negotiation. It might actually be possible to close off some issues and get them settled, which is brilliant. And then you can actually just agree that there are certain issues that would need further negotiation. So it's really about keeping that door open for ongoing discussions. And you can talk with the mediator about how you might do that. A common thing to do is to maybe say that the mediation confidentiality and without prejudice will stay open for a week, for example, by email, to allow parties to make a few more offers. And then you're therefore agreeing the next steps with the other party and the mediator. If the mediation is finished, it needs to be quite clear that the mediation is finished, and that you therefore that confidentiality and without prejudice have finished, so that any offers made after that will then be ones which could be reported to the court. Okay, so that takes you through all of that you need to do in a mediation as representing litigants in person. Thank you very much for listening. There are some contact details if you want to get in contact with us. I'd encourage you to look at the CEDR website for further information, and good luck with your mediations. Thank you for listening.